The following is a video that I used for a legal class that I taught, and I just kind of explained how a living trust works. And I go through a full document, a full living trust, and kind of explain the provisions and the analysis and all that. And then there's a link in the notes to, if you want to download that full trust, the sample trust, and then you could use that to read along, or you could just watch the video and read along. What's up, guys? All right, let's do the living trust. A lot of people always ask me about this, and obviously very important if, whether or not you have kids, you don't have kids, you have assets, no one have assets, whatever it is, a living trust is something that's always important. So what I'm going to do is go over what it is and the details of it and kind of explain it. So, this is just the caption page, the front page, and I had to change everything around like name-wise. So these are also fictitious people, obviously. Anthony Mann and Lisa Mann Living Trust, made up a day, the best lawyer. Okay, made up an address. So that's just like the caption page. Okay, then, establishing our trust. Now we get into the nitty-gritty. All right, the date of this trust is October 27, 2020. The parties to this trust are, Anthony Mann, you just put in the first name, and Lisa Mann, the trust makers, and Anthony Mann, Lisa Mann, collectively our trustee, okay? We intend to create a valid trust under the laws of California. Every state has the same kind of system. And under the laws of any state in which the trust created under this trust document is administered. That is in case, the couple moves to Arizona and that they need to administer this trust down the line in Arizona. The terms of this trust prevail over any provision of California law except those provisions that are mandatory and may not be waived. Okay, so what is this? So a couple of terms here. There's the trust makers, and the trustee. Okay, so normally what people do in this situation, so let's say you have this husband and wife, let's say they're both 50 years old, okay, and they have one kid who's 20, all right? And what they do here is they are what's called the trust makers or the trustors. They're the ones that are creating all of this, right? And the trustee means it's a person or a bank or a company. In some cases, there's a professional trustee corporation. They make a lot of money, by the way. So here we have the trust. The trustee is ordinarily, like I said, the person or company that kind of administers and takes care of the trust. And it could be the same person. So here, what they're going to do is while they're alive, they'll be the trustee. So it's their, they'll put their house into the trust and other property and their savings into the trust. And during their lives, they will be the ones that are the trustees, which is, obviously totally allowed. Okay. Identifying our trust to the extent practical, the purpose of transferring the property to our trust or identifying our trust. The trust shall be identified as, this is just the name of the trust, okay? Just so that people know how to identify it. Reliance by third parties to protect the confidentiality of this instrument. Our trustee may use a certificate of trust that identifies our trustee and sets forth authority of our trustee to transact business on behalf. So what this means is a third party, let's read this part, a third party dealing with our trust is not required to inquire into the terms of the instrument of the authority. Okay, so what this means, so let's say they create this trust and they have a very nice house in freaking Modesto, California, right? And the trust is now going to own the house. So they go from owning it as Anthony Mann and Lisa Mann, and they transfer it to this trust called Anthony Mann Lisa Mann Trust. Okay, so someday in the future, they may want to sell the house or they may want to refinance the house, right? It would be a bummer if every time they tried to do something, they would have to show this whole trust. So what this says is suffice it that instead of having to do all that, this trust authorizes the trustee to sell the house or buy the house or refinance the house. And the trustee doesn't have to bring all the trust documents. They want to keep it confidential. They could just bring like one certificate saying, I am the trustee of the Anthony Mann Trust, Anthony Mann Lisa Mann Trust, okay? Probate code section provides that a person making a demand for the trust document in addition to the certificate of exchange may be liable for damages, including as a result of refusal to accept the certificate of trust. Meaning, there is a law that if the bank or someone else, you just give them the certificate and you don't have to give them the whole trust. Okay, transferring property to our trust. Okay, by executing this instrument, we transfer Our trustee, $10 in cash. I mean, that's, just made up numbers there, right? Our trustee accepts and agrees to hold $10 as trust property. Any additional property transferred to our trust may be accepted by the trustee. Our trustee shall hold, administer, and dispose of all accepted property. Okay, so what this means is they're going to list here what they transfer to the trustee. Okay, this is different than what they are transferring to the trust. Now, if they put, let's say, a house in the trust and some other things in the trust, sometimes the trustee will need like a capital reserve, so that they could like pay expenses and whatnot. And so that one, like they'll give it directly to the trustee, for example. Okay, so and then the other property will be like it says here. Any community property conveyed to our trust, including the net income from community property and proceeds from the sale of the trust, will retain its character as community property while we are alive and maintained. So that just, oh, by the way, like they own a house together. It's called community property. So even though they're transferring the title to the trust, they're not selling the house. They're not getting rid of the house. So they still own it as husband and wife, even though they don't own it, and it's going to be the trust that owns it. Community property. Any community property transferred to our trust, including the property's income and proceeds from property sales, will retain its character. So that means the property they purchased together while they were married is still going to be community property. Separate property transferred to our trust will retain its character as separate property. Our separate property may be identified as separate property of either of us on attached schedule, the separate property of each. So what the heck does this mean? Let's say the wife has a big inheritance from her family. In every state, that is her separate money. It doesn't become his money. Okay, so if she gets that money, she puts it in the trust. So she just say she gets a $600,000, inheritance, and then she puts all of that in a savings account and under the trust. What this says, that still maintains the character of her separate property. So if they get divorced or something down the line, or if there's any sort of other issue, that is still hers. It is not community property. An amount that is payable to our trust on a life insurance policy that is separate property of either of us will retain its character. That's in case there's some sort of life in if one of them dies and then the other one gets a life insurance money, then that is that person's separate money, and it's not like a community property. Joint tenancy. If joint tenancy with right of survivorship is transferred to our trust, it will be considered to have severed the joint tenancy. What that means is you can own property. If they own property together, it's what's called tenants in common. That means they both own it. One of them dies, then it goes to the will or the trust, however they want that property to go, right? A joint tenancy means if one of them dies, then the other one just inherits the whole property. And what this is saying is if we have anything as joint tenants, if it goes into the trust, it's no longer joint tenancy. It's going to be, either community property or separate property, and it's going to be owned by the trust. Powers reserved by us as trust makers. As trust makers, we retain the power set forth in the section in addition to any powers that we reserve. All right, they're going to have a lot of power. Okay, action on behalf of our trust. Whether both of us are serving as trustee, either or both of us may act for and conduct business on behalf of our trust without consent of any other trustee. So the husband can buy and sell property as he wants, or transfer funds, this and that, and so could the wife. Okay, amendment, restatement, or revocation. Acting jointly, we may amend, restate, or revoke this instrument in whole or in part for any purpose. So now, what this says, you see those words, acting jointly. So as long as when they're both alive, they could amend the trust, they could restate it, and they could revoke it, and they can cancel it. Revoke is like canceling it. So those words are very important, acting jointly. So they could do that acting jointly as long as they're both alive, right? Each of us individually and acting alone may amend, restate, or revoke this trust whole and part as it relates to the acting trustee's separate property. So in that example, the wife put $700,000 in the trust, or $600,000 that was an inheritance from her parents. That's her separate property. So as to that, she and only she can do something to unwind it. Maybe she transfers it from the trust back to herself, or from the trust she lends it to her brother, or her buys a new business or something. And amend, restate, or revoke this trust in whole and part as it relates to the acting trustee's interest in the community property, so long as it does not affect other rights. Okay, so what that means is, let's say it's a little, it could get a little dicey, and let's say there's a $600,000 or a $400,000 retirement account, and it's community property. That means they acquired that during marriage. Let's say he worked and he he put his wages in there, and she put some of her wages in there too, and grew to a $400,000 retirement fund that is a community property. What that says is she could take her half out anytime she wants, the 200,000 of it, but she cannot take his half out. All right, this is just the caption of the footer. Okay. Any amendment, restatement, or revocation must be made in writing and delivered to our then serving trustee. Okay, so obviously if they do anything with their own property, they have to put it in writing and send it to the other trustee. Okay. Addition or removal of trust property. Either of us may add property to the trust. Both of us acting jointly may remove any property from our trust. Each of us acting alone may remove our own separate property. Community property removed from our trust will retain its character. What the heck? Well, didn't they already say this? Sometimes there's some things that are redundant. Anyway, so yeah, it just restates what it said. Control of income and principal distributions. We retain the right to control the distribution of income and principal from our trust. We may direct our trustee to distribute as much of the net income and principal of the trust we consider advisable. Our trustee may distribute the net income and principal to us for unrestricted use and benefit, even to the exhaustion of the trust property. Any undistributed income is to be added to the principal of our trust. So what this means is, while they're alive, let's say the trust has a lot of money in it, they can do whatever the heck they want with it. So they could distribute it, they could sell it, things, they could pay themselves, they can pay their mortgage with it, they could pay their rent with it, they can go on a trip to Riviera Maya with it, whatever they want to do. That is authorizing them, but only they can do that while they're trustees, not like if a new person. Approval of investment decisions. We reserve the absolute right to review and change our trustees' investment decisions, but our trustee is not required to seek our approval before making investment decisions. Okay, so they better have a lot of trust in the trustee, but usually they're the trustees. It's very uncommon that they own all this and that they have some other person become the trustee. Okay, Article 2, family information. This is just kind of, we were married on this date. It's kind of important, when they were married. Because then it may depend on what is community property, what is not. We have one child. I made up, the date and whatnot. But anyway, so all references document to our children are references to this child and any children. References to our descendants are to our children and their descendants, including any deceased child's descendants. It's like if they have grandchildren or whatnot. Okay. And by the way, they don't list who the grandchildren are because maybe they don't have any right now. And they anticipate that one day there may or may not be grandchildren, right? All right, Article 3, trustee succession, okay? This isn't like when the South wanted to secede from the North, okay? What this means is when one party wants to, is no longer going to be, okay, so let me explain. Resignation of a trustee. A trustee may resign by giving written notice to either of us. If we are both incapacitated or deceased, a trustee may resign by giving written notice to the trust's income beneficiaries and to any co-trustees. What this means is this. So yeah, obviously they could resign if they want, or if they hire, let's say they're just too busy, they want to have someone else kind of administer their property, and that person wants to resign, that person is allowed to resign. They just submit a notice to these two people. What this means, if we're both incapacitated or deceased, so if they die or they're unable to make decisions and whatnot, then whoever is like running the show, if they want to resign, then they can do that. They just have to follow this procedure. They have to tell all of the kids and all of the other beneficiaries. And if there's another trustee, they have to tell that other trustee as well. Section 302, trustee succession while both of us are alive. So what this means is if they're the Mr. and Mrs. are both alive, and then they have a different person who's administering everything. And what happens in that situation if we're going to switch trustees? Okay, our right to remove and replace trustees. By joint agreement, we may remove any trustee at any time with or without cause. If a trustee is removed, resigns, or cannot continue to serve for any reason, either or both of us may serve as trustee. We may name a trustee to serve with either or both of us. Okay, so, clearly, so they have someone else that is administrating. They could fire that person anytime they want for no reason at all, if they both agree. If one of us is incapacitated, the other may remove any trustee at any time with or without cause. So you have the Mr. and Mrs., and let's say the Mrs. is incapacitated. She can't do anything. She's really sick. Then the guy can get rid of the trustee. If a trustee is removed, resigns, or cannot serve for any reasons, the non-incapacitated trustee The non-incapacitated trust maker may serve as sole trustee. By the way, you could also, instead of trust maker, you could use the word trustor. Same thing. Okay. Successor trustee during incapacity. During the incapacity of a trust maker, so this is when one, the Mr. or Mrs., the mom or dad get really sick. The other trustee may serve as sole trustee, okay, or the other trust maker. If the other trust maker is unable or unwilling to serve for any reason, then we name trustee number one to serve as successor. They're going to have like backup trustees just in case something happens to them like at the same time and they don't have time to like appoint someone new. They're gonna have like backup trustees, and then ultimately way down the line they'll name a bank or something that that acts as professional trustee. Okay. During any time both of us are incapacitated, a trustee may be removed only for cause. During any time both of us are oh, okay. And only if the removal is approved by a court of competent jurisdiction upon the petition of an interested party. Okay, so what that means is if they're both alive and they're both like really sick, then a trustee stays unless the trustee resigns, or if somebody petitions to court to remove that person as trustee. If no designated trustor if no designated successor trustee is able and willing to act as trustee, the court will name a successor trustee to replace the removed trustee. So if they run out of people that will be trustees, ultimately a court can decide who the trustee is. And that's easy for the court because they appoint, there's like a ton of professional trustee companies out there. Trustee succession after death of either or both of us. This section governs the removal and replacement of our trustees after the death of either or both of us. Upon death of a trust maker, so this is when the mom or dad died. Upon the death of a trust maker, the other trust maker may serve as sole trustee. If the other trust maker is unable or unwilling to serve for any reason, then we name. Didn't I just read this? I swear to God, I just read. Sounds a lot like what we read earlier. Okay, after the death of one of us, the successor trust maker may remove any trustee with or without cause. If the by the way, I joke when I read the same thing, like it sounds like almost exactly the same. Lawyers, I had this one law professor when I went to law school. I went to Berkeley Law School, and I had one law professor. He used to always say, as a lawyer, you got to wear a belt and suspenders. A belt and suspenders. That way, you cover everything. So sometimes that's why there's clauses that kind of sound the same. Coincidentally, I am wearing a belt, but not suspenders. Anyway, okay. After both of our deaths, a trustee may be removed only for cause and only if the removal is approved by a court of competent jurisdiction. If the office of trustee of a trust created under this instrument is vacant and no designated trustor is able to act, any beneficiary may petition a court of competent jurisdiction to name a successor trustee. All right, so that means if they're having a tough time figuring out who could run this, then one of the beneficiaries here, maybe the son or the grandkids when they're older, they could try to go to the court to get a trustee. Unfilled vacancy, any beneficiary may petition the court. See what I'm saying? Didn't we just read that? The court petition to name a trustee will acquire jurisdiction over the trust only to the extent necessary to make the appointment. A minor or incapacitated beneficiary's parent or legal representative may act on his behalf. So that, so if they have like a grandkid who's a minor, then that grandkid's parent, which would be their son or daughter, can act. Okay, appointment of a co-trustee. Any individual serving as our trustee may name an individual or corporate fiduciary as co-trustee. Fiduciary just means somebody that's going to like do something in trust for them. The appointed co-trustee will not become a successor trustee upon the death, designation, or incapacity of the trustee or trustee's naming the co-trustee unless specified. Oh, so what this means is, let's say there's a trustee and they have a partner or a buddy or someone they work with a lot. They could name that person as co-trustee. But when the trustee dies, the co-trustee does not become the trustee. They're just eliminated, and then it goes to the successor trustee. Corporate fiduciaries. Any corporate fiduciary serving under this instrument as trustee must be a bank, trust company, or public charity that is qualified to act as fiduciary. Like I said, they make a lot of money. Incapacity of a trustee. So this is a trustee that is alive, but then becomes really sick or, whatever. Okay, they're mentally ill or something. Or they just can't, they can't do anything. Okay, if any individual trustee becomes incapacitated, the incapacitated trustee need not resign as trustee. For trustees other than one of us, a written good faith declaration of incapacity by the co-trustee, or if none, by the party designated to succeed the incapacitated trustee, will terminate the trust. By the way, the whole incapacity of a trustee, that's always a big deal. And that is litigated a lot. Okay, because it's like they're like, oh, we got to get my dad. My dad's losing it, and he's giving away all our money. Let's get him out as trustee, or something like that. If the trustee designated in the written declaration objects in writing to the termination of a trustee within 5 days, so these are rules about what we do in case one of the trustee is kind of losing it mentally or physically, or both. Appointment of an independent special trustee. Isn't it crazy? A lot of people don't read and understand this when they get a trust. That's why I'm doing this. Appointment of independent special trustee. My goodness. If the trustee of any trust created under this instrument is unwilling or unable to act with respect to any trust property or any provision of this instrument for any reason, the trustee may name a corporate fiduciary or individual to act as an independent special trustee with respect to the property or provision. The appointing trustee may revoke the appointment at will. So all that means is, for some reason, let's say the trustee is trying to sell a piece of property, and like very occasionally they'll say something like, "Oh, that property could only be sold if by a resident in this area, or that property can only be sold if you're physically here to sign it off, or something," and that trustee can't make it, or the trustee is away at war, or on vacation. There's some sort of emergency. They could appoint a special trustee just for that transaction, and then they could what's it called? Yank them out of that. Okay, documenting change of trustee status. Any appointment, removal, resignation, or any change in trusteeship, that'd be a good spelling bee word, must be in writing and must be signed by the person or persons exercising the power. The written notice must be dated. Okay, all that jazz. Notice of removal and appointment. Notice of removal must be delivered to the trustee being removed. Yeah, obviously, right? And to any other then serving trustees. The notice of removal will be effective in accordance with its provisions. Notice of appointment must be delivered to the successor trustee and any then serving trustees. Yeah, so in addition to the notice of removal, so does the notice of appointment. Gosh, why didn't they just say notice of removal and notice of appointment? Anyway, the appointment will be effective time of acceptance. Okay, prohibited trustees. Whoa, these are people that cannot be trustees. Notwithstanding anything in this instrument to the contrary, a beneficiary of a special needs trust established under this instrument may not at any time serve as trustee of the special needs trust. So, gosh, what that means is sometimes, God forbid, like one of their kids, let's say, is disabled or something, and then they have a special kind of, they call it special needs, like special needs for that person, or the person's young and they're going away to college or something. So if somebody is getting some sort of special needs from the trust, then that person cannot become a trustee. If a beneficiary has been nominated to serve as trustee of the special needs trust, the nomination will be null and void, and the remaining provisions will be fine. Okay. So Article 4 of our famous trust, administration of our trust during a trust maker's incapacity. So what they're talking about here, this article will relate to if one of the two, the mom or dad, become ill and unable to perform or do anything. During any period which one of us is incapacitated, our trustee shall make distribution authorized in this article from the community property and the incapacitated trust maker's separate property. Okay, so remember that example? Let's say the wife gets an inheritance of $600,000. If she becomes incapacitated, the husband can make a distribution, means like a payment from the trust to out of the trust, so that they could be rent, mortgage, it could be for food, airplane, car, whatever. The husband can take that money from the community property or from her inheritance. If she is the one taking care of the husband, she doesn't have to take it from her separate property. Okay, distributions for the incapacitated trustor's benefit. Our trustee shall regularly and conscientiously make appropriate distributions of the net income and principal for the general welfare and comfort of an incapacitated trustor. So they got to take care of the other spouse, right? Our trustee may make distributions for the benefit of an incapacitated trust maker in any one of the following ways: to the incapacitated trust maker, to the extent he or she is able to manage these distributions; to the person or entities, to an agent or attorney in fact authorized to act on the behalf to a guardian or conservator of the trust. Okay, so that's kind of like some of the things that they could pay on behalf of the incapacitated spouse. Distributions for the benefit of the other trust maker and our dependents. Our trustee may distribute as much of the net income and principal of our trustee as our trustee considers necessary for the health, education, maintenance, or support of the non-incapacitated trust maker. So they can do whatever the heck they want. Our trustee may also distribute as much of the net income and principal as our trustee considers necessary for the health, education, of other persons that our trustee determines to be dependent on the incapacitated trust. So they can take care of the kids and the kids' kids and that type of thing. Guidance for making distributions. And once again, the distribution is taking money out of the trust and paying something. When making distributions under Section 401 and 402, our trustee shall give consideration first to our needs and then to the needs of those dependent on us. So, it's mom and dad that are putting this together. So this just says that they better take care of them first. When making distributions under 402, we request that our trustee, with the sole and absolute discretion, consider other income and resources available to the dependents. That means if they're able and they're making other money, the kids, you don't have to keep paying them, right? A distribution made to a beneficiary under this section will not be considered an advancement and will not be charged against the share. So what that means is, let's say ultimately there's one son and 4 grandchildren, right? And then let's say the son dies, and then there's 4 grandchildren that ultimately inherit this. If one of those 4 got a few disbursements, they still get 1/4 of what's remaining. What this says is that any disbursement wasn't an advance on her 1/4 share. That's what this trust says. Okay, Article 5. The fun just keeps going. Okay, administration of our trust upon the death of a trust maker. So mom or dad dies. All right, let's say in this example, we just say the dad dies first. Okay. Section 501, surviving trust makers, trust property, and the deceased trust maker. So surviving is the wife, okay, her trust property, and the deceased and the husband's trust property. Okay, after one of us dies, the surviving trust maker's interest in any community property of our trust and the surviving trust maker's separate trust property will be referred to as the surviving trust maker's trust property. Okay. The surviving trust maker's trust property will be referred to as the survivor's trust, and our trustee shall administer the survivor's trust as provided in Article 7. The deceased trust maker's interest in any community property of our trust and the deceased trust maker's separate property will be referred to as the deceased trust maker's trust property. So, look, the dad died, right? So here, the money that was, okay, the surviving spouse, her separate property would be considered in the surviving trust maker's trust property. His share of the community property, so his half of the interest in community property, that is in the deceased trust maker's trust property, and her share of the community property are in her surviving trustor's trust property. There is a big difference because you're going to see ultimately what can be revoked and what can't be revoked. And anything, he died, so his deceased trust maker's trust property, it cannot be revoked anymore because he's dead. So that property is going to have to be treated differently than her property. Payment of expenses and taxes. Our trustee may pay from the deceased trust maker's trust property. Get this. Expenses of the deceased trust maker's last illness, funeral. Okay, that's fair. You pay for the guy that died, his funeral expenses. You could take it from his money, his share. Legally enforceable claims against the deceased trust maker. So he owed, some money to somebody. Expenses of administering the trust. Okay, court order allowances for those dependent upon the deceased trust maker. I guess if there's like child support payments or some sort of other payments. These payments are discretionary with our trustee. Our trustee may make decisions on these payments. Okay, if payment would decrease the federal tax charitable deduction available to the trust maker's estate, our trustee may not pay any administrative expenses. Okay. If payment would decrease the federal estate tax marital deduction available to the deceased trust maker's estate, my goodness, our trustee may not pay any administrative expenses from the net income. So it's just basically this. It's difficult to do a trust because you have to kind of anticipate what the tax burdens be, and those always change. A new politician comes around and like, we want to raise the estate tax and things like that. That's why the trust, you have to get it checked out every few years. Okay, excluding life insurance proceeds from creditors. That's big. Despite anything to the contrary, any life insurance proceeds available to the trustee under this instrument must never be or become part of our probate or testamentary estate. Nothing in this instrument. So yeah, because life insurance, somebody dies and they had life insurance, the person that gets the life insurance money, as long as they keep it separate, they don't have to use that money to pay off creditors and stuff. Payment of death taxes. Such a sad, death taxes, like how much more? Those are two bad words in the same thing, right? And payment, three bad words. Payment, death taxes. Okay. For purpose of this article, the term death taxes refers to any taxes imposed by any reason of the deceased trust maker's death. Okay, so more or less it's going to end up saying that that money could come from the deceased trust maker's estate. Authority to elect portability. The applicable exclusion amount is defined under IRS code. After the death of one of us, if the deceased trust maker's applicable exclusion amount cannot fully be fully used, and the deceased trust maker does not have a duly appointed personal representative, then we nominate our trustee to serve as the deceased. Okay, we authorize our trustee in its sole and absolute discretion when acting as the deceased trust maker is saved. Okay, so basically this is just, like, you got to be careful how you treat certain tax things because of the estate tax. And look, there's a ginormous tax benefit to the kids, and that's what's called a stepped up basis. So you just have to be careful how this is done, because the stepped up basis means this. Let's say the mom and dad had a property that they purchased for $200,000 in 1999. So in 1999, they purchased a house for $200,000, right? And in the year 2026, let's say that house is worth $2 million. It went from $200,000 to $2 million. When they die and the kids end up inheriting it, then the basis of that property goes up to $2 million right away. It's like the basis of the time of death. So then if the kids turn around and sell that house the next day for $2 million, they pay zero tax on it. Okay? And so this is kind of like things like how to make sure you do that appropriately and whatnot. Okay? All right, so let's keep going on our living trust. We'll go through this one a little faster, okay? It's a lot of fun. These issues, specific distributions and disposition of tangible personal property, specific gift of residence. When the first trust maker dies, our trustee shall distribute any real property, including buildings and improvements, used by the surviving trustor as his or her personal residence to the survivor's trust. So basically, one person dies, then this is the stuff that's left over. This gift includes insurance policies. Oh, not just stuff, but stuff, property, real property. This gift includes insurance policies on the property and claims under other policies. Our trustee shall distribute the property subject to all liens and encumbrances against the property. So one person dies of the mom and dad, then the other one, the distribution is going to, the stuff that's supposed to go to the other spouse is going to go to the other spouse. If the surviving trust maker disclaims any interest in property distributed under this provision, the interest will be distributed as provided in the article that follows. So she says, I don't want that car, whatever, that will probably end up going to the beneficiaries. Distribution of tangible personal property by memorandum. Little stuff, peculiar stuff. This just, one of the baseball cards to go to this, my son, and I want whatever, this movie collection to go to my daughter, whatever it is. Okay, distribution of remaining tangible personal property. Right, just kind of like explaining how to divide those things. I hate things. I try to have as little as possible. Stuff bugs me. Okay, the survivor's trust. Now remember, we had the mom and dad, and one dies. Then the let's say the wife survived the husband, right? So all of her interest in the community property and her separate property is in the survivor's trust. I used to think, and it's wrong, it's not like it goes somewhere. It's just considered in the survivor's trust, okay? And then he died, so his separate property and his share of the community property goes into the deceased trust. Again, it's not like a physical place. You don't like drive on the freeway and 2 miles till deceased trust's estate. No, it's just like, it's like a conceptualized, it's in that part. Okay. Trustee of the survivor's trust. The surviving trust maker may serve as a sole trustee. The surviving trust maker may remove and replace the trustee. So basically, the mom, let's say, survived the dad, so she could be the trustee, or she could have anyone she wants as the trustee. The survivor trust maker's right to amend. This is important. Okay. The surviving trust maker also has absolute right to amend, restate, revoke the trustor's trust terms, okay, in whole or in part. I think we read this one other time somewhere else. It comes up again. The amendment, restatement, or revocation of the trustor's trust must be in writing and signed by the surviving trustor. The right to amend, restate, or revoke may be exercised only by the surviving trust maker. So this is key. Okay, trustors. Okay, so the mom outlives him. So her share of the community property and her separate property, only that she could revoke or change. The deceased spouse's interest cannot be changed. He's dead, so he can't. I mean, that's it. So whatever is in that deceased trust, that's there. Okay, survivor's trust is the only trust. If the survivor's trust is the only trust established on death of the deceased, a trust maker, a transfer of that trust need not be evidenced by a change of title. It's just like if there's no if the dad died and he had no interest anyway, then this it's all there. Okay, the distribution, basically she could distribute her share any way she wants. She could appoint anyone she wants as the trustee and all that good stuff. Okay. Now administration following the surviving trust maker's death. So she's going to die one day. So what do we do with her trust, the stuff in her estate? The surviving trust becomes irrevocable upon the death of the surviving trust maker, and our trustee shall administer the surviving trust consistent with the provisions of Article 5. So when she dies, then the her share, it's irrevocable because she died, and then the trustee has to follow the beneficiary provisions to see where that money goes. Distribution to our descendants. Our trustee shall distribute our remaining property outright and free of trust to descendants by... Oh, this is just when both the trustor, the mom and dad, are dead, then all of that goes to the decedents. Remote contingent distribution. If at any time no person or entity is qualified to receive final distribution, this portion of the trust estate must be distributed one half to those persons who inherit it, and then the other half to the persons who would inherit. So this is just like if somebody can't be found or they don't want any part of it or something, then half of it should go to what the wife wanted that money to go to, and then half to the whatever the dad wanted if somebody can't be found. Okay. Article 10, distributions to underage and incapacitated beneficiaries, special needs trust. So this is the deal. This is only comes into play if, under any provision of this trust, our trustee is directed to distribute to or benefit of any person receiving or applying for a need-based government benefits or a trustee. So here's the deal. A special needs trust it goes like this. Let's say the mom and dad, they have a son or daughter who is disabled and is an adult that's disabled, or they have a disabled kid or something. Even if they don't have it now, if they have it like after the trust is made. So there needs to be a portion, like you can't give it to the person that is disabled, right? Like they're incapacitated. So you have to keep the trust alive, in the sense that for that special needs beneficiary. It's kind of weird. There's some, what I think is a little, I don't want to call it fraud, but with special needs trust, sometimes if somebody is getting like government benefits, right? If they are getting government benefits and then they have a lot of money, or they come into a lot of money for like a car crash case or an inheritance or something, if they receive that money in their name, then they can't get the benefits, maybe. So a lot of times what is not considered their income or their property is if then that money goes to a special needs trust, and then the special needs trust has a trustee, and then he or she pays out the that person, so that they could live or whatever. I mean, sometimes but that's not a good example, or that's not an example of what should be done. It's just, but that's the idea of the special needs trust, is somebody that can't take care of him or herself, so that there's that trust for that person's benefit. Okay. And there's a lot of rules about that thankfully we'll not get into right now. Okay. Article 11, trust administration, trustee powers. Basically, okay, so no court supervision, so we don't have to look after everything the trustee does. Distribution to beneficiaries, when everyone's the mom and dad are dead, then they could start distributing everything to the beneficiaries. Beneficiary status, until a trustee receives notice of the incapacity, birth, marriage, death, or an event of which a beneficiary's right to receive payments may depend. The trustee is not liable for acting or not acting. Okay, so, the trustee, I guess if they don't know, there's an 8th grandchild, I never knew, then maybe they're not on the hook that they didn't pay that 8th grandchild. Delegation of trustee authority. Basically, any trustee may delegate this right of exercise. So if they need people to help them, especially if it's a big trust. Trustee exoneration. Successor trustors are not obligated to examine the accounts, records, or actions of any previous trustee. What this means is successor trustees are not responsible for any act, forbearance, or omission of any prior. So basically, a new trustee comes in, let's say in the year 2028, that new trustee is not going to be responsible for something that was a screw up of somebody from 2027. This is a no. Self-dealing. If basically, I'll give you the short version of self-dealing. If somebody is a trustee, they can't. There's a it's called a fiduciary obligation to the trust, meaning that trustee has to do what's best for the trust. If the trustee says, "Oh yeah, we needed a property management company for our apartment building, so I hired my property management company and I paid them 25%," right? So that's called like self-dealing. Or, oh, you know what? Somebody's got to live in that nice house. So I'll live in it and I'll pay rent of $1,000 a month when the fair market rent is like $20,000 a month, right? And then they could get paid a little bit. So all of those things are self-dealing, okay? Let's see. Authority to merge or sever trust. This is like if there's like that special needs trust and survivors trust. Like if it makes it easier, they could just consider it together. Okay. The termination of the trust is when if it's no longer economical to administer a trust created, the trustee may terminate the trust. So this one gets disputed a lot. But basically, if there's no more money left, or if there's only one more beneficiary and that's the trustee, or something like that, and then there's just no need to have the trust anymore, then they could just terminate the trust. Okay. Article 12, general provisions, maximum term for trust. Notwithstanding anything to the contrary, each trust created under this document will terminate 21 years after the death of the last. Oh, so this is in law school. We used to study this all the time. It's called the rule of perpetuities, which is like you can't just have something go on forever. So this says the mom and dad, after the last of the two dies, then 21 years after that, the trust has to terminate. All right. Spend a thrift. No beneficiary may assign, anticipate, encumber, alienate. Oh, this is so you have some punk beneficiary, right? This is what they call that he's a trustee baby, right? He's getting money from all the trust, or a trust baby, right? He's getting money from all the trust money. So this one, if that kid gambles, like he gets into a gambling debt, or he wants to buy a house or some sort of stupid investment, he says, "I got an idea. I don't have much money, but I have this trust that keeps paying me or takes care of me. So I'll assign my benefits to you." This disallows that. Okay, contest provision. If somebody, it's really weird. You may give up your right to inherit if you kind of contest the trust in certain ways. Anti-lapse statute, whether existing now, no anti-lapse statute or any other jurisdiction will be applied in construing a beneficiary. So this is just things about how, if it lapses in a certain way, if it terminates in a certain way. Oh my goodness, adopted and after-born persons. A person in any generation who is legally adopted before 18, the same rights as if the person was a natural child. Okay, that's good. That's nice. Let's see, descendants. The term descendants, just the kids from this. Incapacity. So, oh wow. So it is, remember all those times we said if one of them is incapacitated in special needs trust? Well, here we go. If you have an opinion of two licensed physicians, if the court determines it, if they're, if they're in prison, that would be incapacitated under these terms because they can't do much, right? All right, let's keep going. We're running out of time. We're running against the time. Okay. The governing law is usually, because we started this in California. If we did it in a different state, then that would be that other state, right? The heck did I? Oh, okay, sorry. Let's see. Oh, there we are. Okay. Notice the severability. Oh, the invalidity or unenforceability of any provision does not affect the rest. So this just means if one little provision is somewhere is not enforceable, then the rest of it is still enforceable. Okay. They signed the trust. It has to be notarized. This one is they could list, just to make things easier so that there's no dispute later. They list, these 3 houses and this retirement is community property. They could list, the husbands, this is my separate property, this particular inheritance. The wife's separate property, they could list it there, okay? Wow, that is the living trust, my good friends. Let me know if you have any questions about any of this.